Hi, good morning.
CP2024-8, Ricky Raghunanan Limited versus Land Settlement Agency.
Good morning, everyone. Can the parties confirm that they are hearing me correctly? Applicant?
Good morning. Good morning, Hazar Hussein from the LSA. We are hearing you clearly.
Thank you. Good morning once again, everyone. I am David Shallery, presiding as the panel chair today, and I am present with Mr. Robbie Bola, who is on my left, and Mr. Herdis Lichi, who is on my right. The hearing of this matter is set for today. Please note that you will also see on today's session Ms. Valerie Kelsick and Ms. Susan Torrey. They will be appearing as participants and teams. These are members of the board and they are here for educational purposes only. They are not part of the panel. Can the representative for the applicant confirm that you agree to permit said members to be part of the proceedings today as observers?
Chairman, permission granted.
The representative of the respondent, do you consent?
Chairman, no objection to that.
Thank you. Is the applicant or a representative for the applicant present? May I have your names, please? Your name, please?
Chairman, Atri Balrup of Ricky Raghunanan Limited, present.
Is the respondent or a representative for the respondent present? May I have your name, please?
Chairman Hazar Hussein, CEO of the LSA, present.
Thank you. Before we commence proceedings today, I would like to go through some house rules in order to effectively manage today's session. So, one, ensure that you mute your microphone when you are not addressing the panel. Remember to unmute your microphone when it's your turn to speak and speak directly into the microphone. Where multiple devices are in use, please mute all of the other devices that are not being used to speak into. Avoid interrupting a speaker. Let the speaker finish before you attempt to do so. You may use the raise hand feature in Teams when you're desirous of interrupting a speaker or you wish to say something. Ensure that you are clearly visible by maintaining a reasonable distance from the camera to show your head and upper body. It must be remembered that witnesses must not be able to hear the evidence of other witnesses and therefore would not be allowed to have access to any ongoing open link until the time has arisen for their evidence to be taken. This also applies to physical presence. So if you have more than one witness or if you have several witnesses in your party, the witnesses are not allowed to hear the presentations of the other witnesses. No unauthorized recording of the proceedings is allowed. Parties to the proceedings can request access to the record of the hearing by filing the prescribed Form 16 to the office. In the event that any connection is lost or we're interrupted by whatever cause, representatives and parties must immediately notify the hearing secretary by calling 868-4677 or 868-226-4677, extension 1162. In your communication, you must state the precise time at which you either lost connectivity or you were interrupted. And you must also confirm this as soon as practicable by email to challenge@opr.org.tt with the case reference number in the subject line and copy to all other parties in this matter. With that being said, we may commence proceedings today in accordance with Part 5 of the Act, the challenge proceeding regulations, and Part 10 of the hearing rules and procedures. So the first item I would like to address is preliminary matters. There is a preliminary matter that the panel would like to address before I invite the applicant and respondent to indicate if they have any preliminary matters. So the preliminary issue on the part of the panel would be the skeletal submission of the respondent. The panel received a request by the respondent for an extension of time to file the skeletal submissions on the 15th of May 2024 at 3:29 p.m. The request asked the panel to authorize the skeletal submissions by 6 p.m. We were informed by our case team that the submission was made before 6 p.m. by the respondent. So therefore, leave is granted by the respondent to file the skeletal submissions after 4 p.m. and also to allow for the stamping of the document as at the 15th of May 2024. Respondent, can you confirm that the document was served on the applicant? Respondent? And respondent as well, I would like to note that you're out of frame of the camera. We are seeing half of your body. Thank you. Yes, can you confirm that the document was served on the applicant? You are on mute, respondent.
Chairman, are you hearing me now?
Yes, we are. Thank you.
Okay. Chairman, the document was submitted to the OPR yesterday afternoon, as indicated.
Are you confirming that it was not provided to the applicant?
It was this morning provided to the applicant.
It was provided at today's date. Okay.
Yes.
Thank you very much. Thank you very much. Applicant, do you have any preliminary matters to raise?
Confirming if the skeletal submission was indeed sent to the respondent on your part.
Could I ask for a moment to confirm with the team, please?
No problem.
Thank you, applicant. In response to your question, it is to be noted that it is the responsibility of the applicant and or respondent to serve notice on the respective parties and then verify by submitting a Form 1. Did you serve and submit your Form 1s? Form 1?
No, it was not served for the purpose of this was submitted to the OPR to challenge at OPR.gov.tt. However, we did not receive the stamped copy from you all and the directions to serve the same to the respondent. We would have followed that procedure for the witness statement. We got back the stamped copy and we served them the stamped copy. However, after we filed the skeletal submission to you yesterday, it was not the stamped copy was not received from the OPR to be able to serve it to the respondent. That is the reason why we did not serve serve the document to them. Yeah.
At 3:56.
Thank you. Let me just confirm one more time with the support team.
Noted.
Thank you, Mr. Balrup. I was advised that it was sent at 7 p.m. However, as it fell out of the working hours, we cannot hold you for service at this time. Respondent, did you receive the documentation?
We received the documentation through the OPRs.
Are you waiving the requirement for being formally served by the applicant? Would you consider?
Yes, sir.
Thank you very
Yes,
much.
we have no issue with that.
Okay, thank you very much. So it is noted that the respondent has waived the requirement for service. Is that the end of your preliminary matters, Mr. Balrup?
Yes, Chairman.
Thank you, Mr. Balrup. Respondent, do you have any preliminary matters to raise at this juncture?
Chairman, at the very onset, we want to indicate that one of our witnesses, Ms. Simone Gordon, is unavoidably absent this morning because of a family emergency. We would like to be guided how that is to be dealt with.
Sure, permit me a few moments, please. Yes, LSA. In response to your preliminary question, the evidence on behalf of the individual Miss Gordon will not be able to be tendered today. In addition, the document that she submitted would have been a witness summary not signed for her, so we would not be able to adduce evidence from that document in the proceedings today. Your response, sir?
No problem, Chairman. Understand.
Thank you very much. At this point in the session, we would now move to the presentation of the case by the parties in the manner set out in Part 10 of the hearing rules and procedures on challenge proceedings. Please note the process would follow the following format, so I'll give you a brief outline of what is to follow. The applicant or representative will be invited to make any opening statements and call the first witness. This opening statement should be brief and it should be approximately 5 minutes. Then there would be the tendering of the witness statements, following which, after tendering of the witness statements, the respondent or their representative will be allowed to cross-examine the witness. In order to keep proceedings smooth today, I would advise that that segment should take approximately 20 minutes. Following the which the respondent or representative is allowed to cross-examine the witness, the panel members may ask questions at that point as well. Similarly, for the respondent, a similar procedure would follow. The respondent or representative would be invited to make any opening statements, again guided by an approximate 5 minutes timeline. So you make your opening statements. Then we have the tendering of witness statements. Then the applicant or the in this case it's the applicant, there is no representative, they will be allowed to cross-examine the witness. And then after the cross-examination, the panel members may also ask questions themselves. So do we are we clear on the process?
Chairman, I'm clear. However, I would just like one little clarification.
Sure.
Would we be able to utilize the skeletal case submission and provide a brief overview of that, probably a summary of it as our opening statement?
Yes, you may.
Okay, thanks.
So I would now like to call on the applicant to make your opening statement. Please proceed, sir.
So good day, members of the panel. Good day to the members of the respondents party. So I am Atri Balrup on behalf of Raghunanan Limited, the applicant. And this submission, so as I indicated previously, I will be utilizing the skeletal case submission, which was made to the OPR yesterday as a form of our opening statements. So just to get to the crux of the matter, Raghunanan Limited would have submitted its application for review of the procurement proceedings on 26th of April regarding challenge of the LSA's notice of decision to award contract ITB 2324-8 tender for development of residential lots, former Petrotrin employees infrastructure works at Zone B, Romain 2, San Fernando. This application was later accepted by the OPR and filed as this challenge proceeding CP2024-8. Raghunanan Limited is of the opinion that the LSA acted in a contrary manner to the requirements set forth within the solicitation documents.
Mr. Balrup, sorry to interrupt. Respondent LSA, I am not seeing you on screen. Apologies, Mr. Balrup. The respondent has dropped off of the screen, so I would ask for a brief pause while we determine what's the cause or what's the matter, if it was technological issues or if he dropped off for whatever reason.
Noted, Chairman.
Okay. I'm just advising that while we are sorting out the issue, the camera will be temporarily turned off, but please do not exit the meeting. The meeting is still going on, although you may not see the panel present. Thank you.
Noted, Chairman.
Your client, sir? Yeah.
Good day, respondent. We noted that you dropped off. Is everything okay on your end?
Chairman, we apologize. We had some technical difficulties on our end.
Okay, and everything is fine now. We may proceed? Okay, thank you.
Everything is fine. We
Okay.
apologize for that.
Applicant, you may restart your submission, seeing that part of it may have been lost by the respondent, so you may begin once again. You may start from the beginning.
Noted, Chairman. So Raghunanan Limited would have submitted its application for review of the procurement proceedings on the 26th of April to the Administrative Review Secretariat of the OPR regarding our challenge of the LSA's Notice of Decision to Award contract for the development of residential lots, particularly Zone B, La Romain 2, San Fernando. This application was later accepted by the OPR and filed as this challenge proceeding CP2024-8. RRL is of the opinion that the LSA acted in a contrary manner to the requirements set forth within the solicitation documents, in particular subsection 2.4.1, the award criteria of the tender document, which was issued to tenderers. RRL is seeking re-evaluation of the tender by the LSA with fair, just, and accurate reference to the terms and conditions of the solicitation documents, in particular subsections 2.3.8 and 2.4.1 award criteria. In reference to both criteria, the requirements for award as explicitly stated as the employer will award the contract to the tenderer, one, whose tender has been determined to be substantially responsive to the tender documents, and two, who has offered the lowest evaluated tender price pursuant to 2.3.8. And in correlation of these two requirements with section 2.4.1, disparities were noted in both areas, which underline the basis for our challenge. Firstly, Raghunanan Limited achieved an overall score of 85 out of 100, which would have surpassed the requirement of the minimum overall score of 70%, as well as a minimum of 50% in both the technical and financial submissions. So RRL's tender is hereby deemed to have been substantially responsive to the tender documents, satisfying the first requirement of award. Then our bid sum was $13,647,727.29. That has been confirmed as the lowest tender price from comparison to the figures of the other 5 evaluated proponents, thereby satisfying the second requirement of section 2.4.1. Within the notice of decision to award contract, the LSA explicitly stated that our company's submissions was evaluated based on the evaluation criteria provided in the solicitation documents, and your company received an overall score of 85 out of 100. Unfortunately, your company did not achieve the highest overall score. And then a table was provided which itemized the scores for both Raghunanan Limited and Calco Limited. And RRL is of the opinion that the justification provided by the LSA, namely your company did not achieve the highest overall score, that statement is completely irrelevant to subsection 2.4.1 of the award criteria, since the requirements for award of contract as stated under 2.4.1 make no mention of the merit of value associated with any tenderer achieving the highest overall score. During the case management conference which was conducted on last Friday, the 10th of May 2024, a statement was made by the Chief Executive Officer of the respondent's party that despite RRL's bid price being the lowest bid price, it was not the lowest evaluated bid price. It was also stated that RRL's bid price was not evaluated since it was outside the permissible range of the engineer's estimate. In light of that, we contend the following. In reference to the financial submission range point allocation, under subsection 2.3.8, we note that 5 marks would have been attributed to profitability ratio, then liquidity ratio 5 marks, quick ratio 5 marks, ROCE 5 marks, 10 marks for reference letter from a financial institution. And then the last criteria under the financial submission gives the lowest bid within the range of the engineer's estimate as 10 marks, and the second lowest bid within the range as 5 marks. And all those previous criteria mentioned would have came to an aggregate total of 40 marks. So the notice of decision to award indicated that we achieved 34 out of 40 in this section, and we hereby infer that we would have been given a minimum of 4 marks under the last criterion, which is in reference to the engineer's estimate. So therefore, we must have gotten at least 4 marks, as I said, sorry. And there's great ambiguity surrounding this particular criterion, because no rubric was provided to guide the point allocation procedure for the third lowest and the fourth lowest and the fifth lowest bid prices, etc. And the clause provided no instructions, no guidelines or provisions regarding the manner in which a bid price will be treated if it is outside of the permissible range of the engineer's estimate. And in the absence of such instructions or guidelines within the solicitation documents, we are hereby guided by Part 3, Clause 34 of the Public Procurement and Disposal of Public Property Act, which basically is around the rejection of abnormally low submissions. And I will just quote that first paragraph of Clause 34 briefly. Where a procuring entity is of the opinion that a submission is abnormally low, it shall request in writing from the supplier or contractor details of the submission which give rise to concerns as to the ability of the supplier or contractor to perform the procurement contract. And it must be noted that at no time during the evaluation was Raghunanan Limited requested to provide details of its submission giving rise to concerns as to its ability to perform the procurement contract. And I would make reference to previous scenarios from the LSA themselves. Up to, I have a letter before me here on the 13th of September regarding another job. I was actually requested to provide a detailed breakdown of a certain component of the bid with supporting evidence that we can execute the work for that kind of price. So the precedent was set by the LSA in the past of requesting from tenderers justification if their price is deemed as substantially low. So nevertheless, the LSA stated that RRL's tender was not the lowest evaluated tender. However, it is clear that we would have scored a minimum of 4 marks under the criterion in relation to the engineer's estimate. Therefore, had it not been evaluated, and those 4 marks could have only been achieved through the process of evaluation. Had it not been evaluated, then we would expect a failed financial submission, right? Another score of 34 out of 40, therefore, as presented on the notice of decision to award. So my point exactly, Chairman, is that we will not, our financial submission was indeed evaluated. A statement was made at the case management conference that they did not evaluate it based on the fact that it was outside the estimate. However, it is clear that for us to achieve 34 out of 40, and for that to go towards our aggregate total of 85 out of 100, our bid or financial submission was not rejected, it was evaluated, right? Notwithstanding the fact that rejection of the submission in the absence of any particular instructions or provisions within the solicitation documents need to be guided by the Public Procurement and Disposal Act, Clause 34. So just in wrapping up, this also, despite the perceived lack of relevance at this point now, it should be noted that up to this point, we have not received the engineer's estimate. It was not disclosed to us. So in summarizing our opening statement, we reiterate the point that the justification provided by the LSA in that your company did not achieve the highest overall score, it is completely irrelevant to the subsection 2.4.1 of the award criteria, since that subsection makes no mention of the merit associated with a tenderer achieving the highest overall score. We reiterate that the LSA has acted in a contrary manner to these requirements. And lastly, my last statement would be that we are seeking re-evaluation of the tender by the LSA with fair and just reference to the terms and conditions of the solicitation documents, in particular subsections 2.3.8 and 2.4.1 of the tender document. Thank you.
Thank you, Mr. Baru. At this point, we'll be moving to the tendering of witness statements. Mr. Baru, I'm noting that you would be the witness on behalf of the applicant. Before the witness statement is tendered, would you be going by way of oath or affirmation? Mr. Baru?
Yes, Chairman, I'll be going by the way of affirmation.
Please give your name when I start. I will prompt you to give your name. I can give your name now.
Atri Balrup.
Please repeat after me. Do solemnly and sincerely and truly affirm
Do solemnly and sincerely affirm
that the evidence
that the evidence
I shall give
to
the hearing panel in this case
the hearing panel in this case
shall be the truth,
shall be the truth,
the whole truth,
of all truth,
and nothing but the truth.
and nothing but the truth.
Thank you, Mr. Baru. I would like you to confirm that it's your signature on the document and the date. If you wish, we may pull the document up so that you can view it and confirm. Do you wish us to pull the document up for your review?
I don't think that's necessary, Chairman. I hereby confirm it's my signature and it was dated the 14th of May 2024.
Okay, so this document is tendered and the initials AB1 will be marked on as that document identification. Respondent, you may now cross-examine the witness. Respondent.
No questions for the applicant and the witness, sorry.
So we will note that the respondent has no questions and has opted not to cross-examine the witness for the applicant. The same process is now following for the respondent. The respondent may now make an opening statement. Hold a sec, please. May I have Thank you. Before we proceed to the respondents' opening statements, I am now inviting members of my panel or members of the panel if they have any further questions, if they have any questions for the applicant.
No questions from me, Chair. Thank you.
Good.
No questions from me, Chair.
There being no further questions from the panel, we may now move to the respondent and his opening submission. You may proceed.
Chairman, the LSA is here to prove that the applicant's tendered price, if accepted, would not be in the best interest of the Land Settlement Agency. The applicant's quoted price would pose significant risks to the successful completion of the project and could compromise the quality, safety, and timeliness and ultimately successful completion of the project. Awarding the contract to the applicant at the submitted tender price is not in the best interest of the Land Settlement Agency. I quote from section 242, acceptance and rejection of tenders. Tenders may be rejected if they are substantially higher than the official budget approved by the employer, Individual tenders may be rejected in cases where the particular tender is so much lower than the official estimate that it's reasonable to conclude that the tenderer will not be able to complete the works within the specified time and the price offered. I go on to quote the analysis bid of $13,647,727.29 was confirmed as the lowest submitted bid price from the tenderer, whilst the price submitted by the applicant was the lowest submitted bid, was not the lowest evaluated price. During the evaluation process, the evaluation committee found that the applicant's submitted bid price was outside of our acceptable engineer's estimate of 19% lower, 15% higher than the engineer's estimate. The range of the engineer's estimate was used by the respondent to determine whether the bid submission reflected a realistic and feasible approach to completing the works within the specified parameters with minimal risk to the respondent. Consequently, the applicant's submitted bid was not considered for the award of contract.
Thank you, respondent. Is that the end of your opening statement?
Yes, sir.
We now move on to presentation of the tendering of the witness statement. You may invite your first witness to tender. Ms. Respondent, you are on mute if you were speaking to the panel.
Chairman, I apologize. I now invite Mr. Satish Baran, our first witness.
I'm asking for a brief pause before we speak to Mr. Baran. Thank you. Mr. Hussain?
Chairman.
Mr. Hussain, seeing that you have more than one witnesses to present, I'm asking for a few things house rules wise. So for example, I would like the witness to be in frame when presenting, and also
yes,
the other witnesses are not to be present in the room, nor should they have access either visually or verbally or in any other manner of the proceedings while this witness is presenting his witness statement. Can you confirm that, please?
Confirm that, Chairman. We confirm.
Okay, Mr. Baran, would you wish to proceed in tandem by way of oath or affirmation?
By way of oath.
Could you present yourself on the screen, please? You're slightly out of frame, more centralized. Thank you very much, sir. You, just to reiterate, you asked for oath or affirmation?
Oath, Chairman.
Oath, okay.
Please repeat after me. I, please state your name.
I, Satish
Solemnly
Baran,
swear. Thank you. Solemnly swear that the evidence
solemnly swear that the evidence
I shall give to the hearing panel
I shall give to the hearing panel
in this case
in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Mr. Baran, I would like you to confirm as well that the signature and date of the documents are indeed what you would have presented to the panel. Would you wish to see the document presented on screen?
That's not necessary, Chairman. I do confirm that the document submitted have my signature attached to it and the date is correct.
Thank you. So this witness statement is hereby tendered as and marked as SB1. I now invite the applicant to cross-examine the witness. Applicant, you have the option to cross-examine the witness at this point in time.
Chairman, I do apologize. However, I failed to indicate earlier that the witness statements from the respondent's party were not served upon us up to this time.
Please permit me a brief pause so that I may verify with my support team. Thank you. I'm guided by my support team who had indicated that the OPR did indeed stamp and send the witness statements to the respondent, and it would have been the responsibility of the respondent to serve to you, Mr. Baru, you are the applicant, to serve to the applicant and provide the Form 1 to the office and the panel. At this juncture, I would advise that we may stand down the proceedings for half an hour to an hour and allow the respondent to serve the applicant the witness statements, following which we would reconvene and continue to hear the challenge. Mr. Baru?
Noted, Chairman.
Respondent?
Noted, Chairman.
So we would be standing down the matter for 1 hour, and I would like the respondent to please serve the documentation to the applicants, following which we would reconvene. It is now 10:54. We would reconvene at 11:54 a.m. Noted?
Noted, Chairman.
Mr. Baru?
Just one clarification, Chairman. So we utilize the same link and log in again at 11:54, right?
Yes.
Because we'll right?
Same links, yes.
Okay, great. Thanks.
Thank you, everyone. This matter is now stood down for 1 hour.